5 years ago, around Valentine's Day, GPT-2, the early precursor to ChatGPT, was released filled with internet data. And the headlines? They said, too dangerous to release, of course. They were so scared of how synthetic content could be done at scale. Well, fast forward to February 2025, last week, and Thomson Reuters just won a summary judgment in an AI fair use copyright. Fair use is what all the major large language models like ChatGPT and Claude are using to defend themselves because it was for research. So Thomson Reuters' victory for its AI content is really found where something that from last week's episode on AI copyright probably wouldn't be considered copyrightable. So while we're all fishing this out, because this is the law, this is brand new stuff, we don't know where to go, we're going to dive into what this means to you. I'm Declan Dunn, and this is the AI Optimist. And this week, it's AI split Valentine. On one side, we have Thomson Reuters getting recognized for AI content. And on the other side, we'll get into that real soon. What can we do to work with these tools together and going forward at least ask permission and protect creators? Though, how do we even make up for just saying, hey, 2020, all of us just sort of took your stuff, it was free, it was on the internet. And I'll tell you at the end how they actually did that and how that opens up so many possibilities, but also is a nest that we can't untangle without really ruining the progress we've made so far. Now, the Thomson Reuters case I was at last week is really interesting because this was a legal firm that publishes legal information, and one of its employees opened a competing firm called Ross Intelligence. Now, what they did was they knew they wanted to get some of the content to train their large language models. So they said, where do we buy it? So they went to Westlaw, which is the company that Reuters owns in the legal circles, and they asked to license it, and they were turned down. Now, they didn't want to give up theirs, so they did something that was really smart and an end around and something that is constantly done, including by ChatGPT and all the others. They buy the data from what are called third parties. So in this case, there was a company called Legalese who has third-party data, all good. So they bought what were called Westlaw's head notes. Think of them like cliff notes for legal cases, which summarize these really intense cases. And they ordered this, as in legal circles are called bulk memos. Give us a set of really good arguments for this case and a really bad set of arguments, sort of the spectrum. So by ordering this through Legalese, they were able to get it from Westlaw, and they published it to train their own database, basically, about 25,000 articles. Now, this is such an eerie comparison to what happened to OpenAI, to Anthropic, to Stability. All of them went to buy data, and pretty much all of them would use third parties. One was called Common Crawl. They have crawled the internet for years. No one really cares. We all sort of gave our permission without knowing. And it really wasn't making a lot of money. There really wasn't that big a deal. But now these companies with billions of dollars go in and buy all this information and this copyright. Now it seems to matter because they're going to generate hundreds of billions, trillions of dollars. So all that content was used to fuel it. But in Thomson Reuters' case, the judge found and actually admitted that sometimes the best wisdom is reviewing what you've said. A federal judge found for Thomson Reuters in what's called summary judgment and said that Ross did not have the right to buy these because the head notes were copyrightable. Now, those head notes came out of an AI content, but they were also human managed. The judge noticed that the decision making, the important things that apply to that case are all in the head notes. So there was a copyrightable compilation. For those who followed my podcast, think Zarya the Dawn again. They love those compilations with AI. That compilation was copyrightable. So Thomson Reuters actually is proof that you can have AI content, or at least content on an AI platform, and if it's put in another person's platform who bought it, supposedly legally, that's not allowed. That's a copyright infringement, and they'll have to take it off. So what we found was that the practice that a lot of the companies did in AI to get their data, a common practice in Silicon Valley. Everybody buys third-party data. It's the end around. No blocks, no regulations. Third parties rarely have rules. These other companies do. So they bought the data and they put it in. But if you compare that to the trillions and trillions of records, images, words downloaded from the internet by OpenAI, by Anthropic, by all of them, it pales in comparison. It doesn't even make sense. If we look at that, then there is a reason to believe that that content really does have a standing for copyright. And if that does, and if the U.S. Copyright Office somehow goes totally rogue and says there's a liability and compensation due for what's went in, then we have about 5 years of data to talk about. Now, I don't really think it's likely to happen, but this is the importance of copyright in what we're talking about. And before we go in, I want to take a little origin story of the Constitution, the U.S. Constitution, which defined the original ideas behind copyright, which weren't done to protect individual rights necessarily. It was also done to encourage, like patents, that this information gets out to the public domain. So let's look at the rules and the wording and what the Copyright Office is trying to do to fulfill a 1787 rule about AI-generated content. Yeah. Even Thomas Jefferson, as smart as he was, couldn't twist his head around what's going on, but hey, he hadn't seen a camera. Let's look at the wording in the Constitution for copyright and how it's turned into a game of authorship. The purpose of copyright is to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right for their respective writings and discoveries. So the Copyright Office right away wants to tie this into how we advance society. This is so important for AI as well. What does AI do to give back? Where is its rules? Well, right now we're trying to see where that fits in. See, their position is that purely created AI works don't promote human progress in their view at this time. And there's a lot of other factors going in. Don't dismiss that the next update, which has to do with how we can actually put information, creativity into the ChatGPTs of the world legally. What's the liability? And is there any compensation for creators? We skipped all this 5-7 years ago, long ago. So where does that play? And how could you give a copyright if you don't know that the liability and the content inside there, where does that fit in your scenario? So understand why they have to move slowly, even though they might want to. And they did note that many of these will be done on a case-by-case basis. See, all copyrights, whether AI or not, have the same durations. They're set out for different things. So if those copyrights are set in stone, you can't just put generative AI in there if you don't really know what you're dealing with and how it gets that information out. Now, the really hard part is in the U.S. is the First Amendment, freedom of speech. I mean, look all over in the last few months. It's crazy the way freedom of speech is used, tooled, weaponized. And if AI has it, then we would have to put freedom of speech on there and it could say anything it wanted and we don't even understand what it's saying. Because then its rights would be protected by free speech. Wow, where will that all come out? But the key battleground is authorship. Always has been. Who is an author? Because from those early days, they realized who actually created and owns this. Where is the origin? So the Office of Copyright, where does it come from? Has to be human. No human, no copyright. Keeps it simple. And honestly, they're not really ready to create what's called a sui generis definition. And remember that. For the end here, we're going to go into how that might work, which is a customized view of how this fits in copyright, because you can't do that till you figure out the deal with the data going in, the creativity going in, and what the responsibilities are for the people who put it in without payment. It's also a focus on substantial human involvement. How much, and this is case by case, but how much was this person involved in creating this? Or how much was the AI involved? That's what makes it hard, because we don't even know how to really explain it what comes out from what we put in. See, when the Constitution talked about respective writings and discoveries, right, it's like back in the day when they didn't have anything but writing. Photography was coming to really blow their minds very soon. But those writings, creativity, has to flow from humans. And AI outputs would only qualify if they show sufficient creative choice. And this is why I'm saying with the New York Times case, it just made sense to me. Because if they're able to pull their content out and prove it and win the case, that actually refutes a lot of this logic around prompting. Or whether the traditional elements of creativity in a work, literary, artistic, musical, are shown and were actually conceived and executed by the machine. See, here's the deal. Does the machine create it? No copyright. Does the human create it with assistance from the machine? Copyright. That's the basis of what this decision came from in a tradition of really trying to figure out chicken or egg. Author, machine. This is an AI chicken or egg. Is it the author? Is it the machine? Is it the prompts? Is it the editing? We don't know. And the easiest thing to say is no, because right now you can't prove that what you put in creates exactly what comes out. And that's one of the rules that they're looking at when awarding copyright. So let's look at the Creator Copyright Playbook. If you're a creator coming out now, I'm going to show you next week some tools to protect your copyrights, whether you're doing text or images. But in the meantime, when AI assists your creativity, you can make a case for copyright. You create the idea, you create the initial part. There's a lot of flexibility to working with the tools because it's working with your idea and your expression. Remember that idea, expression. That's the kind of connection they want to see to show that there was a human effort and that it wasn't just a random thing. Like a Jackson Pollock painting? Nah, but a random thing. When AI generates independently, in other words, I put a couple of prompts in, spits it out, I want a copyright. No, because prompts don't give copyright. Not in China, not in the US as of this time. And it's interesting because you don't really know what's coming out. And if you can prove it, this is what you want to do. Document any of your work with generative AI. And by the way, with anything. If you're not using AI, do the same thing because there's going to be more requirements. And if you can prove it's purely human and there is no AI, maybe seems odd now, but in a few years down the road, this might become something sort of scarce. So make sure you can prove whether you did something with AI or without it and show a record of your activity, photos, manuals, journals, whatever you have, calendars, to keep proof of what you've done. Now, when you transform AI output, when you take AI output and turn it into something else, that's possible to get a copyright, assuming you're not using AI to transform AI, right? Because that's considered as a separate thing doing the creating. Even though you give it the guidance, it's still up to luck as they see it. So AI is a creative assistant. There's a number of works that show. I've talked about Zarya of the Dawn. There are other works that have come up that have definitely proven that there's a human effort into it. And there's no punishment. Even at Amazon, if you're AI assisted, that book can be on Amazon. If you're AI generated purely out of AI, purely by giving prompts, you're supposed to report it to Amazon, and then they will call that an AI generated book. But what's funny is it's very hard to tell what an AI generated text reads compared to one that was generated by a human. I mean, the tools are there, but they're not close to 100%. It's really hard with text to protect it. How do we find those human elements within the creativity, the human elements that came in to create what comes out? Can you see why I'm connecting that with the New York Times? Because they're the only ones I've seen who've actually tried to get out what went in. Or I'm sure others have tried, but I don't think they had the time, money, or ingenuity of the Times to do the prompts. Like they use the first sentences of articles. And if you've ever been in journalism, first sentences are everything to get you to read the book or read the newspaper. So they searched on that. They searched probably on whole articles. We'll find out and I'll keep you updated. But the New York Times, if it happens to be proven true, has actually cracked the code that the U.S. Copyright Office, in a way, says doesn't exist. So pure AI generation is excluded right now because we don't understand it. We think it's all machines, we think it's math, it's probability, and it is all of the above. And it's early days. We don't know where it fits in, and we've got laws that are being made by people that are just really, even the U.S. Copyright Office. In one of the things I was reading about Midjourney, it referred to a parameter that doesn't even exist anymore because this began back in like 2023. That's how fast this stuff moves. And it doesn't mean that they're wrong for trying, but basically they came to the conclusion you could have expected a few years ago. Though they did give their best effort, it's a really hard job, and it doesn't leave any room for AI until we figure out how to handle putting things into AI. Then we can evaluate what comes out and whether it's original, creative, or human enough for copyright, or whether it has to be. So remember, if you're a creator and you're using AI in any way, document your use, especially AI assisted. You want to make sure you just keep a record of this, because as we figure this out, this is the proof you'll need not only to get copyright, but it's becoming more and more important into a world where so much great things are taken and copied. I mean, you have to understand the impact of this, of where this can all be going. I could create a work of art, a painting. Somebody else could take that picture. They could put it into Midjourney or anything else, create a very similar or image or just a little bit off to protect themselves, but basically the same thing. So they qualify for copyright because they put the image in, seems original. We don't really have a way to compare originality. I mean, look at how many copycat products there are. It's just not possible. But then they can come to me with my painting and say, wait, this is like my copyright, and actually have me take it down as the originator. Now, I might know this, but does a court know it? And if I didn't get my copyright, does it matter because this person did? These are the really weird questions we've never had to face before, and why these copyright issues are so important to you, especially as a creator. So here we are, we've looked at this, and I wanted to present to you a case of what's called sui generis AI law, which is probably something they're going to be working on. I can't see this fitting in any other way. Otherwise, they have to make a big legislative change, and that's just probably not going to happen. Now, the reason I'm proposing this sui generis customized view of AI-generated work is because right now there's agencies and people doing work with commissions being told and instructed what to do to create images like cases we've shared with you before, and they'll use AI. But that AI does not convert copyright. And in a normal US work for hire, where I'm a consultant, an agency, an artist, whatever it is for a specific task, the person who creates the work gives the copyright and the entire package to the company or person buying it. That is the normal process. It makes total sense, doesn't it? Then create something with AI and you don't have the copyright. And for the most part, people are just being transparent about it. But if there's any liability, if the AI hallucinated and the person giving it didn't check it, that liability goes to the person who bought it, even though they don't own the copyright. So let's look at a new model of how we might do AI-generated work with authorship and ownership. Clear criteria for determining this. How much effort? Where we go beyond prompts? What's required? How do we even do this with text, which is proven almost impossible to really detect? The duration of protection. One thing people complain about copyrights in traditional ways is how long they are. I mean, I took research back into the history of copyright. There was somebody way back in the Middle Ages in England who for 50 years had the exclusive copyright in the whole area. The only one who was allowed to get copyrights. Does that even make sense? There's other people who've gotten copyrights and then had them taken away. It's a really volatile space. So the duration matters. A lot of people are saying that it's too long today, that you basically in the US, a lot of it's dependent upon your death, and then there's a period after and your people can renew it. But basically, copyright only has a fixed duration. Are those durations too long? Are they based on older days? And for AI generated work, it's clear. We're looking like 5 to 10 years. It's something much shorter because a lot of the purpose of copyright is to put the good stuff into the public domain so they don't have to pay for it. And if this wild amount of creativity with AI happens, and we're just all putting it behind paywalls and different things where you have to have passwords to get in, we're going to miss the whole point of it, aren't we? Fair use and exceptions. Fair use is really important. I'm going to do a whole episode on fair use. Fair use principles say there's reasons for me to use it, like being a journalist, being a researcher. There's many different ways that people can use it and be able to use the content without taking it. It doesn't mean take the book. You might take a quote. This doesn't mean like reporting a whole video. You might take 5 or 10-second clip out of one so you're not impacting the value, because that's what's important with copyright. If your work impacts the future value, that's really damaging. And that is why so many creators are up in arms about AI taking their content, because it is impacting the value, whether you or anyone else thinks it's creative or not. Licensing and attribution. How are we going to license this and how are we going to track it? Because once it gets into the ChatGPTs, you can track to what are called influence vectors maybe, but it's very iffy. This is not like a guaranteed science. So really at the point it goes in, you're going to have to establish some point of either paying for that content or compensating the person who created it or notifying them. And how does that person have a right to say no? Or even better, say no first and have to give you permission rather than permission being assumed as we've done now. Oof, this is where a new case for AI-generated art is so important, because very little of this from the old world really applies. And you hear this in many legal briefings I've looked at. The lawyers agree. The old world rules are really hard to apply here. But first, we still got to figure out what we're doing with putting that data in, who gets paid, is that right, and can we sort of control it and still encourage people's creativity? Now in the US, you'd have a lot of trouble with this kind of law. You would have conflict with limited times requirement. In the Constitution, the copyright clause says for a limited time. If you go to AI generated works, they can be produced so rapidly and in such quantities. Think of like NFTs putting out 256 monkeys. I mean, it's just easy to auto-generate this. Are we going to just create these monopolies and stop the flow of creativity into the public domain? I'm not really sure that's a great argument, but the limited time is going to be shorter. That's sort of the feel I get from most of what I'm looking at. The conflict with author and inventor's requirement. The copyright clause grants exclusive rights to authors and inventors. Generative AI, while it's able to produce creative work, doesn't have that human element and doesn't really know where to put it all together from. It can't really even prove the trail of what created this from individual content. It doesn't make sense in a world of tokens and transformers. So that weird word authors applies, because if you give generative AI recognition as an author, a whole bunch of things start getting open that we never thought of. So as silly as it is, I don't think the people running this have anything against it. There's no place yet. We haven't quite figured it out, which is why I want you to comment, share, let me know what you think what's happening with AI copyright. That's what I'm trying to research and put out so we can provide it as an alternative to just these government, regulatory, big tech approaches to copyright. Get your word in.